ecstatic.
Yeah, we're all so excited. But I wanted to connect with my phone.
Okay, you can't. Right?
Yeah, because you have to have a password. No, not even that. Okay. You have to give that.
What is that? Our camel.
You have to have full access.
All right.
Yeah, no, sorry.
You seated. All right, so Civil Rights Act case today. So, and we have some preliminary motions, I understand. So let's start in with the plaintiff stuff. The plaintiff, as I understand it, seeks to exclude information about an incident where Mr. Kane, the plaintiff, dumped garbage.
Yes,
Tell
that
me
is
what this
correct.
is about, guys.
Yeah, I would like to exclude plaintiff's conviction for malicious mischief where he dumped garbage in the front seat of a guy's car 3 years ago. It's a misdemeanor, and it should be excluded by 404A for character evidence.
So you're saying it can't be used for impeachment under, as a criminal conviction for impeachment under 609. So the only other use would be 404.
Yeah, it would be.
Mr. Duffy, are you going to use that?
You know, I don't intend to use that evidence at all.
All right, that takes care of that. And then the second motion has to do with experimentation with drugs.
Yes.
Experimenting with drugs.
Yes, that is correct, and it should be dismissed for
Who is this who's experimenting with drugs?
the plaintiff.
Oh, the plaintiff was? Okay.
Yeah, and it should be excluded for the exact same reason as I described on the last one.
When was he experimenting with drugs?
He just admitted to have tried a few drugs in the past.
When?
He didn't give a specific
How long
date.
ago, though?
I'm unaware of any specific
You
date,
don't know.
but
All
he
right,
just
how about-
admitted to
How
have.
about that, Mr. Duffy?
You know, I don't intend to introduce that
I
evidence.
can use that either. These are easy. Okay. Mr. Duffy is now seeking to exclude the training or lack of training of the defendant or any evidence concerning the training of Officer Bond. It's a Civil Rights Act case. Doesn't training become relevant?
You know, before coming to court here today, there was actually two defendants. There was Officer Bond and Bayshore City Police Department. The case against the Bayshore City Police Department was dismissed. Therefore, going into any training procedures would be irrelevant, as it's not an essential element of the case before the court today.
Well, what is the case? In other words, what does he have to prove under the Civil Rights Act?
Yes, Your Honor. Under USC 1983, the plaintiff must prove that the officer in question was acting in his duties as a police officer, that an injury occurred, and that he used excessive force in today's case. The training procedures don't affect whether or not excessive force was used.
All right. What do you say about that, Mr. Porter?
The training is highly probative as to what a reasonable officer would do under the circumstances.
But how's it probative, though? What does it tend to show?
It would show if he would have good aim and if he was adequately prepared for the confrontation.
You're saying there are training records that say he does not have good aim?
Well, there's a record describing how this particular officer was trained. I don't intend to use the training procedures for the police department as a whole, but however, just for this particular officer, the defendant in question.
But why does that make any difference how he was trained? It's how he acted, isn't it? Regardless of whether he was trained to do this or that or the other thing.
Well, I would just say that it's definitely relevant. There's a possibility it'll come up later to be relevant to this case.
So, Mr. Duffy, but there's a dispute about exactly what Officer Bond did. Isn't that true?
Yes, Your Honor.
And so wouldn't training tend to show what he was more or less likely to do under those circumstances?
Your Honor, the standard that will be put before the jury today when they're deciding this case is that of a reasonable officer. Bringing in the specific training policies of the Bayshore Police Department don't help them decide how a reasonable officer would have acted in that situation. I'm just seeking to exclude the specific training procedures of the Bayshore City Police Department.
I'm hearing what you're saying, but in there are two pieces. There's how the reasonable officer would have acted, and then you compare that against how this police officer acted. And I thought that how this police officer acted was disputed.
Yes, Your Honor, but we...
So what I'm saying is, if he's told, here's how you're supposed to act, doesn't it make it more likely that that's how he acted given the disputes?
Well, Your Honor, I don't anticipate any evidence being produced today that would suggest that he didn't act in accordance with those policies or procedures or the way he was trained, just the actual actions of that evening. Therefore, the policies and procedures in place...
But what is the evidence of training? Is it specific training, like here's how you're supposed to shoot a gun? I mean, what is it?
Well, there's evidence that he received 20 hours of training for how to shoot a gun, but he also did not receive training on how to deal with dangerous criminal suspect. So I think...
So he didn't get training in something. How does that tend to show how he acted? I think it's probative to show how he would act based on his experiences. I definitely think that. All right. I'm going to deny the motion. I'm going to let you bring in the aspects of training that he in fact had. I don't believe that the training that ideal training, shall we say, is relevant. So if there was a training program that was planned or that used to exist or something, I'm not seeing any relevance for that. Only just how this officer was in fact trained. Okay, and then the second thing is some evidence about Mr. Bond. Now, there's some evidence concerning Mr. Bond and his relationship with one of the witnesses here, and there's some. Tell me exactly what you're trying to keep out here, Mr. Duffy.
Yes, Your Honor, I anticipate that during the course of today's trial, the plaintiff, Mr. Kane, will talk about a statement that a Victoria Cruz, his girlfriend, made to him before coming to court here today. The exact statement is, "I'm not surprised, that guy's a creep. He used to work here as a security guard, and he was always hanging around watching me and trying to look in my windows at night." We seek to exclude this on the grounds that it would be a hearsay statement that should not be brought in through the plaintiff witness.
All right.
I think that if my witness says it on the stand today, that it would no longer be hearsay.
No. If what your witness is saying. Well, which witness are we talking about?
Victoria Curtin.
All right, I think Mr. Duffy was just positing a situation where, in fact, Mr. Kane is repeating what Ms. Curtin told him. Is that what you're talking about?
Yes, and I'm Victoria Curtin's going to be the one that says that.
So you're saying you're not going to have Mr. Kane say that. So what about Ms. Curtin? Do you have any problem with her saying that's her opinion, that's her experience?
If Ms. Curtin makes a statement, then we have no objection to hearsay, only if the plaintiff makes the statement.
Okay, then that's fine. There seems to be no objection to that, so that's and then the third one has to do with some marijuana used by a peripheral witness. Is that the story here?
Yes, Your Honor. One of the witnesses that we are going to call today is an eyewitness by the name of Alexandra Spiro. She was arrested by the military police for possession of marijuana. It was her third offense, and she was given 30 days in the brig and a medical discharge. We seek to exclude this evidence as it has no relevance in today's proceedings, and furthermore, it's explicitly excluded under Rules 608 and 609.
All right.
I can see.
All right. Mr. Porter, what we usually say is, I don't intend to do that. We don't concede anything in open court.
Concede to his motion.
I understood what you meant, and you were absolutely right what you're doing there, and what you're saying, is an accurate word. I'm just saying clients don't like to hear that word. Okay. So that's it. I think we're ready for opening statements.
Your Honor, one more matter.
Yes.
We just seek to invoke Rule 615 that all witnesses are constructively sequestered with the exception of the party representatives.
All right, and who else is there besides? I don't even know who the witnesses are here.
I intend to call today Plaintiff Larry Kane and Victoria Curtin.
In what order?
Larry Kane first and Victoria Curtin second.
Okay, and who do you have?
Officer Bond and Ms. Alexander Spiro.
All right, so I guess what we're gonna say is that Curtin and Spiro will be out until after they testify, is that right?
Yes, Your Honor.
Okay, we're gonna do that. I have no discretion in that.
I would rather call Curtin and Kane today.
Oh, no, you're going to call them both today. I'm just saying that, in theory, we're going to have Ms. Curtin sit outside while you open and while Mr. Kane testifies. After he's done testifying, you can call her to the stand, but she'll just come in from the hallway outside.
Oh, yeah.
When she's done, she's free to leave or free to stay, so long as you don't intend to recall her. All right? So I think we're ready with that?
Yes, Your
All
Honor.
right. Let's have opening statements.
All right. Plaintiff Larry Kane was beaten and shot by defendant Officer Bond. And I'm Dylan Porter, the plaintiff's attorney. I intend to call witnesses Larry Kane, who's plaintiff, and I intend to call Victoria Curtin, who is the girl that Officer Bond shot plaintiff Larry Kane for because he was jealous that he was with her. 2 days before the incident where he got shot, on July 4th, at a July 4th party, Officer Bond arrived and he wanted to break up the party. And where was the party? Victoria Curtin's house. He went in uninvited and unplugged the stereo and then left. Plaintiff Larry Kane, however, thought it's 4th of July. I want to have a 4th of July party. We all should be able to party and have fun. So we went outside to complain to the officer. When he went outside, the officer didn't have it. He pulled his gun on him and said, "I don't ever want to see you at Victoria Curtin's place ever again." Now, 2 days later, Plaintiff Larry Kane was at Victoria's place. It was July 6th. He went over that afternoon, had a steak, she made a salad, they went swimming, so they had dinner, they had a good time, and he left at about 7:30. Now, at 7:30 when he left, he got into a car accident in her apartment complex's parking lot with Miss Spiro, who is a witness that the defense will call. And the officer that responded to the accident was none other than Officer Bond. So Officer Bond was the only officer who responded to the accident. When he did respond, however, he wasn't very friendly to Plaintiff Larry Kane, seeing him over there. Instead, he crowded him, immediately said that it was his fault when, in actuality, Miss Spiro backed into him, made the plaintiff feel really uncomfortable, and he ended up confiscating his car keys, pulling him out of the car, hitting him on the head, actually, with his nightstick, and hitting him on the head twice with his gun. And as Plaintiff Larry Kane wanted to get away, he ran to his car. Officer Bond shot him in the lower back, the right wrist, and he will later claim that he shot him. He will later likely claim that he shot him because he thought that he was going for a weapon, when however actually he was going for his spare car key to get out of there. So, ladies and gentlemen of the jury, I would like to ask that you award the plaintiff $14,920 in medical expenses, $500,000 in pain and suffering, and I believe this behavior is actually so utterly intolerable that he should be awarded $5 million in punitive damages.
All right, and for the defense.
Being a police officer is a dangerous job. We see about it on the news, read about it in the newspapers. But even though we have this general idea that being a police officer is a dangerous profession, we can't truly appreciate the dangerous situations that they actually put themselves into. But at the end of today's trial, ladies and gentlemen, you'll have a sense of what that feeling's like. You'll understand how a police officer feels when they're put into a situation where they fear for their own life. That's why we're here today. Now, Mr. Porter has tried to suggest to you today that the reason we're here is because a police officer used excessive force, and it was out of jealousy. when the truth of the matter is that it's the plaintiff who attacked an officer, made him fear for his own life, and Officer Bond, the defendant, acted in a way any reasonable officer would. Now, good afternoon. My name is James Duffy, and I'm here today on behalf of the defendant, Mr. Officer Bond. And he asked me to come here today to explain to you what actually happened on July 6, 2014. So let's go to July 6, 2014 and talk about what actually happened. Now, on July 6, Officer Bond was doing his routine patrol when he responded to a call of an accident at an apartment complex. When he responded, he saw that two cars had backed into each other. One was driven by Miss Alexandra Spiro. The other was driven by the plaintiff, Mr. Larry Kane. And he'll tell you today that when he showed up to this scene, Mr. Kane became aggressive with him, that he started yelling at him, that he started screaming at him. And then at one point, Mr. Kane tried to leave the scene of the accident. So Officer Bond went over and told him, "You need to stay here. You're being detained until I finish my investigation." Then you'll hear that Mr. Kane, instead of staying there following a lawful command given by a police officer, he decided to take his car door and slam it into Officer Bond, knocking him onto the ground. Officer Bond got up and took the keys out of the plaintiff's car so that he couldn't leave. And he took out his nightstick, and he told him to get out of his car. And you'll hear today that Mr. Kane did get out of his car. But what he did when he got out of his car was he charged at Officer Bond. He went to tackle him. So Officer Bond took his nightstick and he hit Mr. Kane with it. They struggled for a little bit longer, and eventually Mr. Kane got the nightstick. And you'll hear today that he held that nightstick over his head like he was going to strike Officer Bond. So Officer Bond pulled out his weapon and told him to drop it. Mr. Kane didn't drop it. Instead, he took it and he threw it at Officer Bond. Then he went at Officer Bond and tried to tackle him again, and their fight continued. You hear that Officer Bond tried to end this fight by hitting him with the butt end of his gun, using non-lethal force to try to defuse this situation. Eventually, the plaintiff got his hand on Officer Bond's holster where his gun was stored. And you hear that he tried to grab it and use it. Eventually, Officer Bond knocked him to the ground. Now, at this point, they've been struggling for a few minutes. Officer Bond had been hit repeatedly by the plaintiff. And then he saw the plaintiff going over to his car, reaching underneath the seat, and he saw something metallic in his hand. And it was at this point that Officer Bond feared for his life, and he pulled his weapon, and he fired at the plaintiff to protect his own life. Now, in today's case, the plaintiff carries the burden of proof. They must prove to you that it's more likely than not that Officer Bond used excessive force. But I want you to consider the witnesses that they will be calling today to try to prove this case to you. They'll be calling the plaintiff, who, as I already have told you, the evidence will show that he's the one who attacked Officer Bond. And the second witness, Miss Victoria Curtin, she's the plaintiff's girlfriend. Think about why she's here testifying today. So what does this case come down to? Well, it comes down to three simple points. One, that Mr. Kane attacked Officer Bond on July 6, 2014. Two, Officer Bond acted in a way that any reasonable police officer would have to protect themselves and their safety. And three, Officer Bond only used his weapon when he feared for his own life. Now let's start with that first point, the fact that Mr. Kane is the one that attacked Officer Bond. Now you're going to hear from a witness today by the name of Miss Alexandra Spiro. And she has no interest in today's outcome. She's a non-biased eyewitness to what actually happened that evening. And she's going to tell you that what she saw was that Mr. Kane was in his car when Officer Bond asked him to get out. And she will tell you today that his response was that he opened his car door and knocked the officer to the ground. You'll hear today that Officer Bond and Mr. Kane have a previous relationship. That just 2 days earlier, Officer Bond responded to an incident involving Mr. Kane. And that Mr. Kane made a threat to Officer Bond that evening. He made a threat that he would get him back. which leads me to my second point, that on July 6, 2014, Officer Bond used reasonable force to protect himself. Now, the evidence will show here today that when Mr. Kane attacked Officer Bond, he did not pull his weapon immediately. Instead, what he did was he pulled his nightstick. He tried to end the situation by using non-lethal force, and Mr. Kane continued to attack him. He only pulled his weapon when Mr. Kane got hold of the nightstick and went to attack him. And he still didn't fight. Instead, what happened was Mr. Kane threw the nightstick at him, charged at him, and Officer Bond used non-lethal force once again. He tried to hit him over the head with his gun. You'll hear today from Officer Bond that after he got Mr. Kane away from him, he put his gun back in his holster. And that when he did that, Mr. Kane went after his weapon and tried to pull it on him. The evidence will show today, and this leads me to my third point, that he only pulled his weapon when he feared for his life. That after struggling, after fighting with Mr. Kane, being repeatedly attacked for a few minutes, that Officer Bond got knocked to the ground. And the man who just had tried to take his gun was running to his car. He reached under the seat of his car, and he had a metallic object in his hand. And that is when Officer Bond fired his weapon, because he feared for his own life. Now, the plaintiff is going to try to distract you today. They're going to try to suggest that what actually happened was that this was a cop who was jealous, who was over-aggressive, and used excessive force. And I want you to listen closely to all the evidence presented before you today. And if you do that, and if you apply your common sense at the end of today's trial, you'll know what actually happened. You'll know that Mr. Kane attacked an officer carrying out his legal responsibilities, and Officer Bond did everything he could to defuse the situation. And it's for all these reasons that at the end of today's trial, I'll come before you again, and I'll ask that you find Officer Bond not guilty. Thank you.
Thank you, counsel. Members of the jury, I will just mention that this is a civil action rather than a criminal one. Your determination will be whether the plaintiff has proved certain elements of their claim for damages, claim for injury. But that level of proof, unlike a criminal case, is called a preponderance of the evidence, not beyond a reasonable doubt. Preponderance of the evidence simply means that the fact is more likely than not true. Okay, so let's have a witness.
I'd like to call Larry Kane to the stand. Can you please state your name for the jury?
Yeah, my name's Larry Kane.
How old are you?
I'm 27 years old.
Where do you live?
I currently live in Bayshore.
Where do you go to college?
I go to Humboldt.
What was your major in college?
I majored in biology.
Were you involved in any groups?
Yeah, I was in the Humboldt Environmental Society, and I was also involved in the California Nonviolent Peace Coalition while I was in Humboldt.
What exactly does the California Nonviolent Peace Coalition do?
What they do is they use civil disobedience and other nonviolent forms of protest to further the goal of protecting our environment.
Could you elaborate on what civil disobedience and nonviolent protest means?
Yeah, sure. Sit-ins, blocking entrances to, construction sites for nuclear power plants, stuff like that. It does involve breaking the law. Civil disobedience is fundamentally founded in breaking the law, but it was always nonviolent activity.
What do you do for work?
I work with a marine biologist. We collect sea specimens.
Do you have a girlfriend?
I wouldn't say she's my girlfriend, but I do have a relationship with Victoria Curtin, who I see semi-frequently.
How long have you been seeing her for?
About a year.
Let me now bring your attention to the night of July 4th. What happened?
So July 4th was obviously Independence Day. We were having a party at the Knightridge Apartments. That's where Victoria Curtin lives. And at some point during the party, Officer Bond came in. He was in uniform. Pulled the plug in the stereo and told us that we had to quiet down, or else he'd take people in was upset because it was the 4th of July, we weren't making that much noise, so I followed him outside, let him know that I thought we were, entitled to have a good time. He told me something along the lines of, I'll take you in anytime I want, don't F with the police, and I never want to see you here at Victoria's apartment.
Let me now take your attention to the afternoon of July 6th. What did you do that afternoon?
Sure. At about 2 o'clock, I went over to Vicky's house. We went swimming, made lunch. I was there till maybe 7:30ish.
What did you do next?
So I went to the parking lot, went out to my car, and as I was backing out, my car stalled. It was at this point that a woman in a Mercedes, Alexandra Spiro, backed up and hit my car. We got out. There was a dispute about whose fault it was, and a short time later, Officer Bond responded to the scene.
Were there any other officers with Officer Bond?
Officer Bond was alone.
What did the officer do when he arrived at the scene?
Well, first thing he said was, something along the lines of, I bet you're responsible for this. I thought I told you not to come here anymore. That sort of thing.
How did that make you feel?
Objection.
What did you say next?
I don't believe I responded to the police officer directly.
Did you say something to Victoria Curtin?
Objection, meeting.
Overruled.
Yeah, at that point, I was sensing some hostility from Officer Bond, so I asked Vicky to call 911.
Where did you go then?
I went to sit in my car.
How did Officer Bond react to you sitting in your car?
He walked over to my car, opened the door. I think in opening the door, he fell. Then he stood back up and demanded I get out of the car. I said something along the lines of, hey, let's not make this personal. He pulled out his nightstick and then demanded I get out of the car.
What did the officer do next?
Well, I obeyed his command. I got out of the car, and it was at that point that I was struck over the back of the head with his nightstick.
Did he take any objects out of the car?
Yes. Before I got out of the car, he pushed me over towards the passenger seat, reached behind the steering wheel, and pulled the keys out of the ignition.
What did the officer do after he pulled your key out of the ignition?
Again, he commanded me out of the car. I got out of the car and he pushed me over the back of the head with his nightstick.
Were you able to take the stick away from him?
When he went to strike me a second time, yes, I put my hand on the stick. There was a struggle, and I got it from him.
And once you had the stick, what did you do with the stick?
I threw it away. He had a gun. Only a fool would try to assault a police officer with a nightstick when he had a gun.
May I approach the witness, Your Honor?
Yes.
Do you recognize that?
I sure do.
What is it?
This is Officer Bond's nightstick, or a nightstick that Officer Bond had that evening.
How do you know?
I got a good look at it and he hit me over the head with it.
Is it substantially similar as to when you saw it last time that evening?
Yeah, it's about the same condition.
I'd like to offer it into evidence, Your Honor.
No objection.
All right, that's it. That would be trial exhibit 1, doesn't have a sticker.
It says P3.
Well, why don't you grab one of those stickers and write 1.
Where are they? Thank you. What did you think about doing after you threw the stick away from him? Or threw the stick away?
So after I tossed the nightstick, I was standing behind my open car door, so to make sure that I could get out of there, I stepped one step out from behind the car door.
What did the officer do in response to that?
It was at this point that the officer drew his gun from his holster, struck struck me over the back of the head twice, and then returned his gun to his holster.
Did you try and stop him?
Yeah, I tried to shield my head with my hands, but not very effective against their butt-end gun.
How did Officer Bond react to you protecting yourself?
Well, he had his hand back on his gun, and that was in his holster at that point. And to protect myself, I reached out and put my hands, one hand on either side of Officer Bond's waist, one on his gun. His hand was over his gun, so my hand was actually over his, just to prevent him from drawing his firearm. Because I was afraid at that point he was intending to shoot.
After the scuffle with you preventing him from drawing his firearm, where did you go?
I went back to my car.
And what did you do when you got there?
I keep a set of spare keys under the passenger side seat of my car. So I reached under the seat to try to grab my keys
And why did you want to grab your keys?
to leave the seat because I thought Officer Blunt intended to do serious harm.
And why didn't you have the original set of keys with you?
Well, Officer Blunt took them out of the ignition room.
May I approach the witness, Your Honor?
Yep. Show us Mr. Duffy.
Do you recognize that?
Yes, I do.
What is it?
This is my spare set of car keys.
How do you know?
They're my keys.
Is it substantially similar as to when you tried to pull the keys out on July 6th?
Yeah, these are the same keys that I had that day in the passenger seat.
I'd like to offer them into evidence, Your Honor.
No objection, Your Honor.
All right, keys are number 2.
What did the officer say before you when you reached for your set of keys?
He didn't say anything.
What did you see the officer... Oh, sorry, hold on a second. What did you see the officer do after he reached for the set of keys?
Well, it was at that point that he got down on one of his knees, drew his gun from his holster, and was pointing it at me.
May I approach the witness, Your Honor?
Yes.
Do you recognize that?
Yes, I do.
What is it?
This is Officer Bond's firearm.
How do you know?
I got a pretty good look at it when he was pointing it at me.
Is it substantially similar as to when you saw it on July 6th when he was pointing at you?
Yeah, it's the same shape.
I'd like to offer it into evidence, Your Honor.
Objection, Your Honor.
Yes.
Not proper authentication.
So,
May be heard outside the presence of the jury.
yes.
This witness may have saw Officer Bond's gun for a brief moment. We don't know if this is Officer Bond's gun. We don't know if it's the correct serial number. This witness simply lacks the personal knowledge to know whether or not this is Officer Bond's weapon.
I was thinking, Mr. Porter, we're at the bench so that the jury can't hear this. It's just, you're telling me that this person sees this gun twice, basically, right? Once when he's getting smacked on the head with it, the other when he's about 20, 30 feet away, whatever it is. The guy pulls it out, points it at him, he's supposed to recognize it here?
I think during that incident, he definitely got a good look at the gun
I'm not hearing when.
on July 6th.
No, I'm not. I know July 6th. I know when the courts in this. I hear him twice it came out, right? Once when he gets hit over the head, and then once when he gets shot with it.
Yeah.
And so I'm just trying to figure out when during those periods of time is he looking at this gun well enough so he can remember what it looks like here today.
Okay. Did you
No,
also?
we're still at the bench. Where did this gun come from?
This gun came from his holster.
No,
From the
where
officer.
How did you get it? We didn't read that part. That gun, as I understand it, was stipulated to have been produced by the defendants in the course of discovery. Is that right, Mr. Duffy? So that means that when you were asked, give me the gun that Bond had, and you produced this gun. So I think you just kind of got to concede at this point that that's the gun. And that's really the way, Mr. Porter, you should have authenticated it. It's just either, if he wasn't going to stipulate to it, you could have just produced the document, the discovery documents out of
Well, I think if both sides want the gun in evidence, that it should be.
Oh, it's gonna come in. I'm just saying to you that the method you chose to, this is for future use. The method you chose to authenticate it with, by having this witness recognize it, is very unrealistic. But since the defense produced it to you, when you requested it in a civil case, as you did here, you request, you say, produce the gun. And they produced the gun that was used that night. And that's it. And so that's how we know it's the gun that was used that night, is that they told us that. That's an admission of a party opponent, so we're going to let it in. Okay? But just that's the way you should do it, through that process, rather than this witness recognizing it. All right. And by the way, that was a general future use suggestion, because I think there may be other trials where things like that come up, where people recognize things that it's highly unlikely they would really recognize. There's really good ways to put stuff in. So do it the right way. That, Mr. Porter, that will be Exhibit 3.
Yes, Your Honor. What's the next thing you remember happening after you saw the gun being pointed at you?
I remember waking up in the hospital at some point.
What happened at the hospital?
Well, I'd had a cast placed on my wrist. I had undergone surgery to remove a bullet that was lodged in my liver. Things like that.
Where were you shot?
In the back and in the wrist.
Where specifically in the back?
My lower back.
Okay. No more questions, Your Honor.
Cross-examine.
Yes, Your Honor. Remain of 1 moment. May I proceed?
Yes.
Mr. Kane, you don't like the police, do you?
What did I say? I don't like the police.
Well, let's talk about your interactions with the police. First, I'd like to focus your attention on July 4th of 2014.
Sure.
Now, on July 4th, 2014, you were at your girlfriend's house, right?
To use the term loosely, yes.
Victoria Curtin?
Yes.
And she lives at the Night Ridge apartment complex.
Correct.
And she was having a party that evening.
Yeah, correct.
And at some point that evening, Officer Bond showed up, correct?
Yeah.
And he came and he told you guys you were being too loud.
Yeah.
And at one point, he unplugged the stereo.
Correct.
And after doing this, he left.
Right.
He didn't hit anyone when he showed up, did he?
No, that would be a little excessive.
He didn't harass anyone when he showed up, did he?
Objection made.
Unplugging the stereo is kind of harassing people having a good time.
But he didn't physically hurt anyone in the house. Yet you decided to follow him out that evening.
Yeah, I thought we had a right to have a good time. I don't think he had a right to come to a private party and pull the stereo and act like he did.
You know he's a police officer, correct?
Yeah.
So you followed this police officer outside, right?
Yeah.
And at one point you picked up a large stick.
I don't recall picking up a stick.
And then you approached this police officer, right?
I approached him, but not with a stick.
And at one point he pulled his weapon on you.
Yeah, pretty quickly.
And he told you to drop the stick that you had in your hand.
I wasn't carrying a stick.
And then you got into your car and you left.
Yeah.
And then you said to him, I'll get you for this, you son of a bitch, right?
Yeah, I meant report him to his the police force he works for.
Just so the jury clearly understands, you said, I'll get you for this, you son of a bitch, right?
Yeah, as in report him, but I never did, because I figured it was no big deal.
Now, let's talk about July 6th. July 6th, you were back at the Night Ridge apartment complex, correct?
Yes, I was.
And you were at Victoria's house once again.
Yeah.
Now, you have an on and off again relationship with this woman?
Yeah, I guess you could say that, yeah.
Now, you left around 7:30 p.m., correct?
Yep.
And the reason you had to leave was because she was actually having another date come over that night.
I don't know about that.
And then you went outside, right?
Yep.
And you got into your car.
Yep.
And then you got into an accident in that parking lot with a Miss Alexandra Spiro.
Yes, I did.
And after you got into this accident, you got out and you started yelling at her.
Well, I wouldn't say I was yelling at her, but we had a disagreement about whose fault it was in the accident. I think it was mutual.
You thought it was her fault.
Yeah.
And you were upset that she hit your car.
Yeah, of course I was, yeah.
And then Officer Bond showed up.
Yep.
And you had a discussion with Officer Bond.
Yeah.
And then at one point, he went back to his police cruiser after initially talking to you, correct?
I don't remember quite exactly what happened.
Well, after talking to Officer Bond, you went to your car, right?
Yeah, I went to my car, yeah.
You didn't tell Miss Curtin that you were going to your car, did you?
No.
You didn't tell Officer Bond that you were going to your car.
No, I didn't.
In fact, right before you went to your car, Miss Curtin grabbed your arm.
Yeah, I remember that happening.
And then your response was to shove her.
Yeah, she was trying to get me to calm down. I wanted her to call 911. I was a little upset, Officer Bond, came in saying it was my fault before he knew kind of what happened. Yeah, I was upset at that.
So you did push her?
Yeah.
Now, when you got into your car, Officer Bond came over, right?
Yes, he did.
And he told you to get out of the car.
Yeah.
He told you that you were under arrest.
I don't remember him telling me I was under arrest now.
And you shoved the door and knocked into the ground, didn't you?
He opened the door, I didn't.
Well, let's talk about what happened after he got knocked on the ground. At one point, you had this nightstick in your hand, correct?
Yes, I did. I took it from him after he hit me once.
And just to clarify, before he pulled this nightstick, he did not pull his weapon at that point, right?
No, he did not. By that you mean his gun?
Yes.
No, he did not draw his gun.
And you guys got into a struggle, right?
After he hit me, yeah, I tried to get the stick from him, yeah.
And like you said, you eventually got hold of it.
Correct.
And then you held it over your head like this, right?
No, I didn't.
And then you went after Officer Bond.
No, I didn't. I threw the stick away.
Now, eventually, the stick ended up on the ground.
Yeah, because I threw it, yeah.
You threw it?
Yes, not towards Officer
Now-
Bond's direction.
Mr. Kane, after you threw this stick, eventually Officer Bond pulled his gun on you.
Yes.
He didn't fire at this point, though, correct?
No, he did not.
You charged at him again.
No, I didn't.
And he struck you over the head with the butt end of the gun,
Oh, yeah, he hit me twice.
and then he put the gun back in his holster.
Correct, yes, he did.
Now, as you already said on direct examination, at one point you had your hand on top of his hand on his hip, correct?
Yeah, I thought he was going to draw his gun and fire.
His hand was on his gun, right?
Yeah, already, yeah.
And then he got knocked to the ground.
Yeah, it could happen, yeah.
So after he got knocked to the ground, you went back to your car,
Yep.
and the door was still open from when you opened it, right?
Yeah, that's all.
And when you got back to the car, you were reaching underneath the seat, correct?
Yeah, I got my keys, yeah.
And just to clarify, those keys are a metallic object, right?
Yeah, keys are all usually down.
And it was at this point that Officer Bond fired his weapon at you.
Well, I don't remember him firing the gun, but I know he pointed it at me and I did it. Yeah, he fired his gun.
And you were shot in the wrist?
Yep, and in the lower.
No further questions, John?
Okay. Redirect.
Mr. Kane,
Yes.
have you ever once hit Officer Bond?
No, I don't remember hitting him, no.
No more questions.
Okay, you can step down. Next one. Next one.
I would like to call Victoria Curtin to the stand.
You may assume you've been not sworn to tell the truth, as was the last witness.
Please state your name for the jury.
Victoria Lee Curtin,
How old are you?
27.
Where were you born?
I was born in Atlanta, Georgia,
Where did you go to college?
Ohio State.
What were your majors in college?
Economics and business.
What did you do after college?
I traveled around Europe for like 6 months, and then I worked in New York at Citibank as an assistant manager.
Why did you return to Bayshore?
My mom got really sick.
Where do you currently work?
I work at the Women's Health Club, the gym.
How would you describe your health?
It's good. I'm in good health.
Where do you currently live?
At the Night Ridge Apartments,
What did you do on July 4th?
I threw a 4th of July party.
Who was there?
A bunch of my friends and Larry Kane.
How long have you known Larry Kane?
Like a year and a half.
How would you describe your relationship with Mr. Kane?
We're like on again, off again. He's not really my boyfriend. We're casual.
Who showed up at your party uninvited?
Officer
Objection,
Bond.
Your Honor. Lack of personal knowledge may be heard briefly.
Yes.
Assume we're outside the presence of the jury. During the time that Officer Bond showed up to this party, this witness was actually outside in the pool and has no idea what actually happened inside the party at this point in time.
Mr. Porter? How does this witness know who showed up at the party?
Well, Larry Kane told her that he called her and told her that the officer showed up, and that's a
All right,
statement
well,
of a
But
party.
that's not enough unless she's actually observed this. She can't testify to that fact. It's a statement.
Did he? How are you personally acquainted with Officer Bond?
He was the security guard previously at my apartment complex, and I had all sorts of problems with him.
Why did you have problems with him?
He was
Objection,
creepy.
relevance.
What's the problems?
What?
What are the problems we're going to hear?
Motive to attack the
And
plaintiff.
what are they, though? What is she going to say? She's not going to say motive. She's going to say something.
She's going to say specifically that he came to her apartment sometimes and kind of was a creep asking her out. She wasn't interested. It's a statement that we decided during the motions of Lamine that should be admitted.
As motions eliminate. I agree. I think this that interaction between this witness and the defendant is relevant. So I'm going to overrule the objection.
Let me ask the question again. Why did you have problems with him, with Officer Bond?
He was creepy. He would stare at women in the pool, and he would ask me out every 2 weeks. And once I caught him peering through my window, so I had to make sure the curtains were always drawn.
How has he treated your other male friends?
He's hassled many of them.
What did you do on the afternoon of July 6th?
I had Larry over, and he came over around 2, and we made dinner and we hung out.
What did you see happen? What did you see happen after Larry Kane left?
So Larry left, and I heard a collision in the parking lot, and he had gotten into an accident with Miss Spiro.
What officer did you see responded to the scene?
It was Officer Bond,
What was he wearing when he came to the scene?
his police uniform.
What happened when Officer Bond arrived at the scene?
He started screaming at Larry, and Larry was saying something like, "It's not my fault," and he told him to shut up, or I'll shut your mouth, or I'll shut it for you, something like that. And then Larry got back in his car.
What did you see Officer Bond do next?
So he ran over to Larry's car and grabbed the handle and fell back.
Where did you see where was the officer's hand when it happened?
It was on Larry's car door handle.
How far away from the car were you?
I was 15 feet away.
What did Bond do next?
So he pulled Larry out and then grabbed his nightstick and started hitting Larry over the head with his nightstick.
What did you do when this happened?
I started screaming and tried to stop them, and then I screamed. There was people who had gathered around the parking lot to watch, and I told them to call the police.
What did you see next?
So what happened next was Officer Bond pulled out his gun and he called Larry a son of a bitch. And then Larry kind of looked like he was taking a step forward, and then he turned around and looked like he was running, and Officer Bond hit him over the head with a gun, and Larry just fell to the ground.
Where did you go next after this happened?
I ran into my apartment to call the police.
What did you hear when you were inside your apartment?
I heard several gunshots.
And what did you see when you came outside?
Larry was next to his car bleeding.
Where did you go next?
I went to the hospital with Larry.
How long was he there?
2 weeks.
What did you see when you were there at the hospital?
He had tubes coming out of his side, and he had his arm in a cast, and it was pretty scary.
How generally did Larry feel when he was at the hospital?
Objection, speculation.
Sustained.
How generally did Larry feel after he got out of the hospital and was hanging out with you?
Objection, speculation.
And more questions, Your Honor.
Pass it down.
Yes, Your Honor. Good afternoon, Ms. Kerr.
Hi.
You know Larry Kane, correct?
Mhm.
You guys have had an intimate relationship
Yeah.
for about a year now.
Yeah, about.
I want to talk to you a little bit about July 6, 2014.
Sure.
You were at your apartment that day,
Yes.
and you live in the Knightbridge apartment complex. And Mr. Kane came over to your house,
Mhm.
and you left around 7:30.
Yes.
And the reason he was leaving was because you were having another date come over.
Yeah.
Now, Larry can be kind of possessive, can he?
No, I think if anything, Larry's not serious enough.
So is it your testimony here today that Larry is not possessive?
I mean, he's been like jealous before, but you know, he's acted like a typical guy from time to time.
Ms. Kerr, just so the jury fully understands,
Yeah.
is your testimony that Mr. Kane is not a possessive guy?
I may have called him possessive before, but overall, I don't think he's any different than what a lot of women are used to.
Now, he knew that you had another date coming over that evening.
Actually, I'm not sure. He may have.
Well, you guys got into an argument before he left.
Yeah, it wasn't really. It was. I don't really remember what it was about. I don't know if it was about that date per se.
And when he was at your place, he had about 4 or 5 beers?
I think it was around 4, but he didn't seem drunk to me.
Now, then he went outside to the parking lot.
Yeah.
And eventually, you know that an accident occurred
Yes.
outside. Now, you went outside to see what was happening.
Mhm.
And you saw Mr. Kane there, correct?
Yes.
And you saw the woman that he had crashed into.
Yes.
And you would describe Mr. Kane as being angry.
Yeah, he was worked out.
And at one point, you actually grabbed his arm to try to calm him down.
Mhm.
And he pushed you away at that point.
Yeah, he kind of wanted to get me out of the way.
And then Officer Bond showed up, right?
Yes.
Now, you know who Officer Bond is.
Yes.
He's a police officer.
Yes.
He was in uniform when he showed up.
Yes, he was.
Now, at one point, Officer Bond went back to his police cruiser, correct?
Mhm.
And it was at this point that Mr. Kane went back to his car.
Oh, I believe so. Yeah.
Mr. Kane didn't tell you that he was going to his car, right?
No, we weren't. He wasn't talking to me at all.
You didn't hear Mr. Kane tell Officer Bond that he was going to his car.
I don't believe so.
And it was at that point that Officer Bond went over to the car and told Mr. Kane that he was actually under arrest.
I didn't hear him say that.
And then you saw a struggle happen between the two of them.
Yes.
Now, at some point during the struggle, Mr. Kane had a nightstick in his hand, correct?
I didn't see that.
And then you went into the house, right?
Eventually, yeah.
And you heard gunshots.
Yes.
So you didn't see Officer Bond shoot Mr. Kane.
No.
You didn't see anything that happened in those last few minutes of the struggle.
No.
I want to transition a little bit. I want to talk about your work history, Ms. Kerr.
Mhm.
Now, you used to work for Citibank,
Yes.
correct? And you were asked to resign from Citibank.
Yes.
And the reason that you were asked to resign was because there was $150,000 missing from your department,
Yeah.
and you tried to cover that up, correct?
Yeah, it was complicated though.
And you actually filed a false quarterly report,
Once again, it was a complicated matter.
and you got caught lying, right?
I don't know if it was called lying, but like I said, it was complicated.
No further questions, Your Honor.
Redirect.
No questions, Your Honor.
Step down. All right. Anything else from the plaintiff?
Arrest my case, Your Honor.
Okay. Mr. Duffy, will you excuse the jury?
Yes, Your Honor. At this time, I'd like to move for a judgment as a matter of law, specifically that the plaintiff has failed to prove that the deprivation of rights approximately caused the injuries in today's case. Viewing the facts presented in the light most favorable to the plaintiff, a reasonable jury could not find that Officer Bond's actions that evening in depriving him of his liberty directly caused the injuries that Mr. Kane sustained.
What do you mean that? Okay. It's the excessive force in the course of the arrest you're talking about, the Fourth Amendment excessive force.
Yes, Your Honor.
So the excessive force caused the injury. I'm not seeing any dispute about that.
Your Honor, an element of it is that they have to establish that him depriving him of his rights by seizing him caused the injury. We would argue that Mr. Kane's actions to attack Officer Bond were an intervening cause, and that was actually the proximate cause of his injuries, and not the action of Officer Bond detaining him that evening.
All right. Mr. Porter, you have any thoughts?
Officer Bond did detain him that evening and was in his police uniform the whole time, responding to what he would consider a routine traffic accident.
Yes. Let me, I'm still not catching the distinction, right? So what it says here is that, and it was injured as a proximate cause, result of conduct by a police officer. Oh, that's, I'm sorry, that's the next, that's the wrong one. Plaintiff acted under the apparent. Plaintiff was injured as a proximate result of defendant's conduct. Take us to what how the element reads. So it seems like the conduct is more broadly, I think you're looking at it very narrowly. I do though, I'm trying to figure out though, over here, Mr. Porter, have you proven the citizenship of your client?
Yeah, he lives in Bayshore, and he went to Humboldt College, Humboldt State.
Gonna come here as an exchange student?
Well,
Staying
Bayshore.
over his visa, he
Well,
might
he's
not
a
even be legal, I don't know.
He's a citizen in Bayshore, which is a city in the United States,
How do we know he's a citizen in Bayshore?
because he lives there.
No, people live places not citizens of the place. You need to be a citizen of the United States to invoke this action, apparently under 42 U.S.C. Section 1983. It would appear that unless you are a citizen, the police are free to violate your rights. We are going to be, however, in light of the fact that I totally disagree with that proposition being the appropriate one, I'm going to violate the law, and we're going to move forward. Mr. Duffy, be prepared to defend your client on Wednesday. That was the reason.